set up minutes, we'll let you run it. He should set up the agenda and we'll let him run.
I have nothing to do.
Oh, now you've got a backup. Yeah. Okay, it's after 10, we go. Ready?
Yes.
Ready. Okay, welcome to the July 26th, 2024 meeting of the Knox County Board of Assessment Review. The meeting will come to order. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are offered. Please notify the chair if you are unable to hear or to see. The board expects that this hearing and the subsequent deliberation will take no longer than 2 hours in total. The board works from a prepared agenda. There is one item on today's agenda: the hearing of the appeal of Edward Libby for Pacific Premier Trust to this board of the denial of his appeal to the Camden assessor in the matter of the assessment of his property at 47 Riverside Drive, map 107, lot 37. Any person wishing to address the board may do so in accordance with the following procedures. The board will initially confirm with the applicant and the assessor the current assessed value of the property and the requested abatement amount. The board will then open the public hearing and ask the appellant to present his case briefly and concisely. The board has studied the submitted material, so please just present your points with your proof of them. The board expects this part of the hearing to take no longer than 15 minutes. The board members will then have an opportunity to ask questions of the appellant, and the assessor will have an opportunity to ask questions of the appellant. The board will then ask the assessor to present his case briefly and concisely, presenting his points and proof of them. The board expects this part of the hearing to take no longer than 15 minutes. The board members will then have an opportunity to ask questions of the assessor, and the appellant will have an opportunity to ask questions of the assessor. When there is no further testimony from either side, the board will then close the public hearing and deliberate and make a decision on the abatement appeal. Following a decision on the appeal toward the end of the meeting or at a subsequent meeting shortly thereafter, the board will prepare a written decision that will be mailed to the applicant within 10 days of the board's vote. The board may receive any oral or documentary evidence, but such evidence is restricted to the subject matter of the agenda item. The board has studied the submissions of the parties. The board shall exclude irrelevant, immaterial, or unduly repetitious evidence. Citizens shall refrain from interrupting other speakers. This meeting is being electronically recorded, and it is very difficult to hear what is being said when multiple people speak at the same time. Citizens shall avoid personalities and conduct themselves in a civil, courteous manner expected of all meeting participants. Speakers should address questions through the chair. Speakers shall not attempt to engage in debate with other meeting participants. Any questions? If none, then let us move to the first agenda item, the abatement appeal of Edward Libby for Pacific Premier Trust on his property at 47 Riverside Drive, Camden, tax map 107, lot 37. Anyone wishing to testify in this matter, please stand, raise your right hand, and repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
So I swear to tell the truth, the whole truth, and nothing but the truth.
Thank you very much. You may be seated. Let us first confirm the ownership of the parcel. Edward Libby for Pacific Premier Trust. Is that correctly stated, and the sole owner?
Yes.
Let us confirm the current assessed value of the property and the requested abatement amount. We have, according to the application, the assessment of the land is $314,400. The assessment of the buildings is $93,800 for a total assessment of $408,200. Is that correct?
I can't speak to that.
Is the assessor in agreement with these figures?
Yes.
Good. According to the application, the owner's opinion of current value of land is 0, building is 0, and total is 0.
I just wanted to point out that this is, we're a whole year past now, so I don't, when you refer to the current assessment, I don't know if you're referring to the current as of.
No, we're talking about the assessment that we're talking about, which is the one we are having a hearing about, which is 23, not 24.
Before this, but
Okay.
The one you appealed on.
Yeah, that was the current as of 2023, because the new one, it just came out, didn't it? Yeah,
Yeah.
okay. I just wanted
We can argue about that next time.
We won't need to.
Okay, so, the abatement requested is $408,200, which is 100% difference, so it certainly meets the state requirement. The appellant is citing the judgment of the assessor was irrational or so unreasonable in light of the circumstances that the property is substantially overvalued and that injustice results, and there was unjust discrimination, and the assessment was fraudulent, dishonest, or illegal. The tax year for which the abatement is requested is April 1st, 2023. Is that called fiscal year 2023? Sometimes they're not the same. I would entertain a motion to stipulate that the appellant has or does not have standing in the matter by virtue of his ownership of the property.
I'll make a motion. I'll second.
Second. All in favor?
That he does have standing.
He does have standing. 1, 2, 3, 4, 5, 6, 7. Thank you. I'll try to do this better. I would entertain a motion to stipulate the appellant's application to this board was timely filed.
So moved. Second.
Thank you. All in favor? 1, 2, 3, 4, 5, 6, 7. Thank you. We're on the third page already. All right. All right, the appellant may present his case.
Okay, thank you very much. I appreciate everybody coming. I know it's summer in Maine. All the better places to be than here right now, especially on such a nice day. It's an interesting case. It's really has to do with the timing and the legality and when the approval took effect, and we'll get to that. But one thing, as I sit here as a private citizen without an attorney next to me, and then I have the town of Camden on the other side with an attorney, oftentimes that looks very lopsided, and perhaps a board like you may weigh the opinion and the presentation of the town and the attorney more. But I just want to point out that prior to my abatement request was actually a request to the town of Camden to actually split this lot to begin with, which is why this whole thing has been started. And in that process, the town of Camden initially told me that it wasn't legal to do that. And then, as I pressed the issue, because of my personal background as a real estate developer and being very familiar with land use law, I pressed the town of Camden on that, and they asked their own attorney, the same attorney here, Mr. Kelly, to review that. And I have the email here from that time from Clint Beveridge that says to me, after looking into our code and all the code references you provided, we passed this on to the town attorney to verify our findings. Those findings were that I could not divide the property. And then this is from Bill Kelly that says to the town code officer and the town planner that, quote, I have looked into the request to divide this lot into 2 separate parcels. And then it goes on for 4 paragraphs concluding, thus, for the reasons described above, it appears to me that this lot, due to its inability to be divided and meet the shoreline area minimum lot size and shorefront requirements, cannot be divided. Later, that obviously changed, and my position prevailed. So it's my position that the town and Mr. Kelly are, once again, are not looking at the appropriate law, and that's what I'm here to talk about today. I received, as did you, a pretty thick document on behalf of the town from Mr. Kelly, and I just wanted to point out there were 4 things that I felt were flawed in his argument. The first is, as a matter of law, by way of example, he misstates the subdivision law, which he's trying to use as a comparison. I would like also to use the subdivision law as a comparison because I think it is very aligned with the situation that we have here. But Mr. Kelly states on page 2 of his letter that the common example would be a planning board subdivision approval which created the right to market and sell lots, but does not require that the lots be reflected in the recorded deeds. That's actually the opposite of what the subdivision ordinance says. What Mr. Kelly is trying to say is that when the planning board approves a subdivision, there is created a right to market and sell the lots. This is very, very similar to the situation that I'm in. And in fact, the subdivision law does not allow, upon the approval by the board, for a developer or anyone to market and sell those lots. What the law requires, and I have it here and I'll submit it, it's Title 30A, Section 4406, which requires 2 steps before you can market and sell the lots. First, you have to get the approval. And I'll read from this, it's number 1, sales and other conveyances. No person may sell, lease, develop, or build upon any land in a subdivision that has not been approved by the municipal reviewing authority of the municipality where the subdivision is located and approved, and subsequently recorded in the proper registry of deeds. So in other words, Mr. Kelly is trying to present the fact that once the board made the decision to approve the subdivision, that the developer can go and sell the lots. And that's simply not true, and there's a vast difference. Because the developer, if unable to sell those lots, the value of those lots, if you're unable to sell them, is vastly different than once you record the subdivision and now you can sell the lots. And this is critical to the exact situation that I'm in a parallel situation where it was the Zoning Board of Appeals in the place of the Planning Board as the decision-making authority. And that comes to the second flaw in Mr. Kelly's presentation in this letter, where he suggests again on page 2 that what I'm trying to argue, Mr. Louis, I'll quote, Mr. Louis suggests that the written form of the decision is the controlling date as to the approval granted by the town. He says this premise is incorrect. Well, that is not the premise that I've made. The premise I've made is that the lots were not, the value of the lots were not fully vested as comparable lots until that plan was recorded. And the reason I say that is because of the letter that I got from the Zoning Board of Appeals on March 24th, 2023, titled Notice of Decision, where the Board of Appeals says, quote, that document will need to be recorded at the registry along with the survey. Okay, now I take will need to be for what it says in plain language. It doesn't say that the document and the survey could be recorded or might be recorded, and it doesn't omit. It speaks directly to the fact that the notice that they made and the signed plan needs to be recorded. Very, very similar, parallel to the sequence of events as if it was the planning board. And the difference between a subdivision and what I have here is truly the difference of 1 lot. If this had been 3 lots, it would have been a subdivision. But it was not, it was a division. Most folks can divide a lot without going to any board. If you own a piece of property and you feel that you meet all of the requirements, you can simply divide your lot, and then the recording of the deed does create a new lot. In this case, though, it was an unusual circumstance, and by town ordinance, the division was required to go to the Board of Appeals for approval. Okay, once I enter into that regime and that paradigm where I have to go to a regulatory authority, then I'm following their rules. And if they say to me that I must record the plan that they've approved, then I must record the plan. And why that's important is for potential future users. I just want to go back to four pieces of Mr. Kelly's presentation to you. One of them, the third one, is that the basis of his primary argument, he spends a lot of time, and all of the case law that he submits at the end has to do with talking about the decision and the appeals, the appeal clock. And there are two complete different things. I don't disagree that when that board made the decision on that day, the appeals clock started. It's exactly the same as in the subdivision. The day the planning board makes the decision, the appeals clock starts. And that is a matter of necessity, because if you are someone who may contend a decision, you have to have a date certain by which some clock starts. But there are other things that are going on, again, going back to the subdivision as a comparable example, as well as mine. The state law requires that that plan then must be recorded. Well, there are varying times depending on the town, but the state, again, as a matter of statute, as I said, they do require that the plan be recorded, but they also go on to say that the municipalities, this is section 4408, says upon the approval of a subdivision plan, a municipality may not require less than 90 days for the subdivision plan to be recorded in the registry of deeds. In other words, they're giving the subdivider at least 90 days to go down and record that. And then after that, some towns have varying timelines where you have to get into the registry and record. So I'm not arguing, there are case after case after case in here about when the appeals clock starts. That has nothing to do with what I'm here for. It's irrelevant to my argument. I understand the appeals clock started, but the appeals clock can in fact run out before somebody perfects either their subdivision plan or, in my case, record the plan that was approved by the Board of Appeals. And then the fourth piece was that, and this is on page 5 of Mr. Kelly's presentation, he says that the conditions of approval are not determinative in this case. He says neither the vote of approval on March 22nd, the notice of decision, which you have a copy of, on March 24th, nor the confirmatory written decision on April 10th require a deed or deeds or the division survey plan to be recorded in the registry of deeds. And I want to repeat this, I'll paraphrase. The notice of decision did not require the recording of the plan. But if you read this, it says that document will need to be recorded in the registry. That is completely two opposite things. He's trying to claim that they didn't require me to record the plan, and yet if you look at the document that he's actually citing, it says that I must record the plan. So if I'm required to record the plan, that creates a situation that there's another step before the decision is perfected. It's exactly the same as in the subdivision. I do subdivisions all the time. In fact, I have one currently right in this exact thing, in limbo. In the town of Yarmouth, on July 10th, I had a 3-lot subdivision approved. going back to the appeals clock, that appeals clock started on July 10th. But as of yesterday, I happened to run into one of the planning board members at the farmer's market in Yarmouth, and I asked her, please, could you go down to the town office and sign that plan, because I need to get the majority of the planning board members to sign that plan, so I can then take that plan and bring it to the registry and record it so that I can begin to sell those lots. Okay, but right now, I'm in this limbo. If you imagine right now, we're back in April, and we're in that transition time. And as of April 1st, I submitted, and you have an unsigned plan. On April 1st, that is what I had, an unsigned plan that the Board of Appeals said I must have signed and recorded. But it hadn't happened yet on April 1st, and so those lots did not have the same rights. I couldn't go down to the town office on April 1st with an unsigned plan that must be recorded and ask the code officer for a building permit. He wouldn't have given it to me. Okay, because if I can't get a building permit to build on my property, how can it possibly have the same value as the lot next door when they can just go and get a building permit? So if the Board of Appeals had not said in the notice of decision that I must record the plan, I wouldn't be here right now. But because they did, and if you look at that letter, it's copied to the code officer in the town of Camden, so he's on notice that if I try to come in and get a building permit on this newly created lot, unless I've got this recorded, they're not going to give it to me. And I would like to just suggest to you that Mr. Kelly represents people that purchase property. And if I tried to sell that piece of property to somebody before this plan was signed and recorded, and that person came into Mr. Kelly and said, I'm trying to buy this piece of property, Mr. Kelly would have said, well, hold on just a minute. You shouldn't buy that yet because it hasn't been signed and it hasn't been recorded as required by the Board of Appeals in Camden. He would have made sure that his client, in protecting their interest, would not have purchased that property until that had happened. And that is what this is all about. I have another example. Again, I understand the law and I can read and understand it. I've been around it for 35 years. But a lot of what I'm talking about and experience is what I'm trying to convey. And I have another situation. I just explained the situation that I'm literally in right now in Yarmouth, and I'm in this same limbo. But I had an experience just a month or two ago in the town of Rockport, where I put a piece of property under contract to purchase. Part of that had been an approval for a site plan. And part of that site plan approval required that the Department of Transportation, this was on Route 1, there was an entrance permit that was required for that site plan to be approved. Well, in my due diligence in looking at that property and wondering, is everything kosher, I decided I would check with the DOT to make sure that that permit was in fact in place. And part of what that permit process is you apply for the permit. The permit was issued. Okay, so again, it's like getting that decision on that day. But the permit said that it must be recorded in the Registry of Deeds and returned to the DOT. Well, what I found out was that the DOT had issued the permit, but the person I was buying the property from had never recorded it. And so I got a letter back, and I submitted this letter that says, this is from the Maine DOT, I just checked the original permit and waiver, and it was revoked, as the waiver was never recorded with the County Registry of Deeds within the 90 days of issues. Okay, so you can see how value, if something had changed in between, and for some reason now, a year later, I wasn't able to get an access permit off Route 1 for that property, that would change the value of that property quite a bit. So in other words, yes, the permit had been issued, but it wasn't final until the steps that were required by the DOT to be recorded and returned to them. It's no different than the Board of Appeals at the end of March giving the approval for my lot split. but telling me I had to record the plan, but then that plan didn't get recorded until later in April. So in that interim period, as we passed through that critical date on April 1st, when the value of the lot had to be determined, that lot did not have all the privileges and rights vested because the plan hadn't been signed by the Board of Appeals, nor had it been recorded in the Registry of Deeds as it was required to be. And that is the whole premise of the argument. I'm not arguing about what the land is worth today, what it's worth once all these things are taken care of. What I'm saying is, as of April 1st, on that day, when I can't get a permit from the town and I haven't perfected what the zoning board of appeals required me to do, then it can't have the same value. And it's substantially less value. And in this case, the numbers, I don't have them on the top of my head, but basically what the town did was they took the value of the entire property and it nearly doubled. They tried to assign almost the same value to each of the lots a few days later. And sort of what I'm trying to say is, well, you can't yet do that, and it's a substantial difference. The assessment should have reflected something more like what it had been until all that stuff had happened. So it's just because it's on this particular date. If it had been a different month, it wouldn't matter, but it was this particular date, and the town is required to assess it, the value as of that date, April 1st. And if I can't get a building permit and I haven't done the things that the town has required me to do, then the town can't then turn around and assess it yet for that. They have to wait as well, which would have been the subsequent year. So I think that I would like to submit the subdivision statute, because I hadn't submitted that before, so people can see that was a flaw in Mr. Kelly's argument. And I think that's the only extra thing I have that I hadn't submitted before. And that's it for me today. I'm happy to answer any questions if the board has any.
Okay. Does the board have any questions?
Yes, I do. What was your closing date when you purchased the property from the Paynes?
It was in March, and I'm glad you asked that question, because it's another little wrinkle, but I think it's important to point out. The way this was done was that when I went under contract with the Paynes, it was one parcel, and I asked them for permission to pursue this process. They had actually pursued it years prior, and the town had denied them the same request. But the point I want to make is that I purchased it as two separate entities. So when I closed on the Paynes, I didn't purchase one property, I purchased it. But those were related entities. I just wanted them to be separate. So the trust, which has this property, is really controlled by me. So where I was in control of all those things, it didn't really matter too much to me, because I was deeding it essentially to an entity that I controlled. I also was responsible to go and perfect the decision by recording the plan. 99.9% of the time, it would be a different situation where I had purchased the property from the Paynes, had the division, and then it would be like offering for sale to you. Now, of course, you would be, again, in the example I gave, if you had an attorney and they were helping you and you were looking at this, they would say, well, this hasn't been done yet, you need to wait. With me, because I had both entities, the deeding happened in late March,
Okay.
even though the things that the Board of Appeals required hadn't been done, but because I was the same entity, or essentially the same entity, it didn't matter to me because I had complete control over it.
Any other questions?
Not for me.
Yeah.
What's the time frame for recording plans through the town of Camden? Examples appeals size? Is it 90 days, 120 days?
I don't know.
So, good question again. I tried to look it up yesterday, but there was something about the, I couldn't get it to come up on the thing. I do know, and I actually brought it with me, because I was able to look it up. I can read this for you. This is not completely relevant, but I was able to find it in the town of Yarmouth, and it may be different for Camden, but,
It's a different town.
yeah, okay.
Um,
It can't be less than 90 days, I knew that,
right,
for subdivision,
right.
okay?
But this isn't a.
It's not a subdivision, that's the thing, it's not exactly, they don't have as many rules.
It is a subdivision. Not in the subdivision definition, but it is a subdividing of a lot that required town approval.
Yes,
So
it's a division.
It's a lot amongst lots, and you're dividing it, so obviously, all those lots along the road are a subdivision, and you are subdividing within the
So
subdivision.
yeah, no, this is a division, this division does not, the subdivision law does not apply. I've been talking about it only as a parallel, because it's similar. It's a separate zoning piece that talks about dividing these shorefront lots and engages then this zoning board of appeals process. The zoning board of appeals process doesn't specify a date certain in the future that it must be recorded. They simply said it must be recorded.
to follow up, so would it be your opinion that you never recorded the zoning board of appeals plan, that would still be one lot today?
No, that is not my opinion. What my opinion is that the value of the lot would be different. Okay, it didn't say that I couldn't sell the lot, because I actually did it beforehand, selling, conveying. But to be able to go in and get the approvals and have that approval be perfected, it must be recorded. Do you see what I'm saying? Same thing as a subdivision. You got 10 lots there. Say you get an approval for a 10-lot subdivision, and it's on paper, and they're there, and the town will assess those however they may. Now, the developer in the future still must record the plan. The value of those lots, because they can't sell the lots until they record the plan, so they're all sitting there on paper, and it may show up on the town map, but until you can sell them, until you've recorded the plan and you can sell them, their value is very different. And then Mr. Kelly used in his example, well, you might have to build roads. Well, that will affect the value too. The town may come in and incrementally change the value if you've recorded the lots as separate lots. But if the roads aren't built, those lots will go up in value again once those roads are built later. So there is a series of things that will change the value of the lots as those requirements of the subdivision come into play. There are towns, and I don't know if it's a state law, but I know there are towns that would also say you can do all those things, but then if you don't start the construction, then those approvals could expire at some point in the future. So there are some things that come later that impact the value of the lots, but not the fact that you could deed them. I mean, the subdivision law says you can't deed them until it's recorded. But the zoning board of appeals process did not say that they couldn't be transferred. But any person who wants to buy a waterfront property, and it went through a very scrutinized process that required the zoning board of appeals to approve it, and the zoning board of appeals said that the plan had to be recorded, any attorney is going to advise that person to not purchase that until they get that thing recorded properly.
So we'll circle back around a little bit.
Yeah.
On June 1st, hypothetically, 2023, you have 2 lots approved by the zoning board of appeals, but you've not recorded the plan. You cannot sell those lots separately. Would that be your opinion?
No.
You think they,
You said
They
June
already
1st.
were.
Did you mean June first?
No, as an example. So at a later date, you've not recorded the subdivision plan. Do you have one lot or two?
There are two,
If you're saying that the two lots aren't valid until the plan's recorded, then some months later, you still have one lot because you've not recorded the plan.
so I think there's nuance here. I'm not saying the two lots aren't valid. I'm saying the value of the lots are vastly different. Because if I can own the lot, but if I go into the town to get a permit, and the code officer says, we required you to record that plan, I'm gonna deny you a building permit on this lot because you haven't recorded the plan. That is the essence of my argument. The value of that lot, you can own it, but it's just not worth the same as the neighboring lot where you can just go in and get a building permit and build your house.
So it's your opinion that the value of the building and land is zero? That's what you put on your application?
It is, and the reason I did that is because essentially the value in March before, it was essentially doubled. So I'm saying somehow that should have been the same value until the recording of the plan that made the decision and approval to split the lot.
But you just suggested that under my scenario, you had two lots. So what's the demonstration of the other value of the lot that shouldn't have been split? I don't think you can have it both ways.
I'm not sure I even follow your question.
Who would pick up the tab for the extra taxes? You know, would it go back on lot 37? Because you're two separate owners.
Yes, I mean, you bring up a good point. And maybe I should have come in with an appeal for both lots and had, you know, a reduced value on both. I just simply said, well, here's the other one, and dropped it down. Maybe there's some value to it, maybe it's not zero, but it's certainly not the same as a lot that's next door that is able to go in and get permits and has all the vested rights of any other lot in town. So, I mean, maybe I should be in here arguing for both, that both were in limbo, but I'm here just arguing on the one.
Done? Tom has a question.
I just wonder how you came up with a value of $408,200. In item 6 of your statement of manifestly wrong, you say the combined value of the lots is assessed at $855,000 plus, compared to $547,800 the day before.
Okay.
Okay, I would submit that it's not the day before. That was the April 22 assessment. That lot, had it been assessed as a single lot, would have been worth substantially more than $547,000. So you're comparing apples to oranges here. You're looking at a combined value for two new lots, and then you're comparing it to the assessed value for the single lot, which was a year before. I mean, if you're a real estate developer, you know what had happened to assessments around here. I mean, the assessments have skyrocketed. So you can't legitimately compare the combined value of those two lots to the single value a year prior. Can't do it.
Well, what I think is true though is that on March 30th, the assessed value was the whatever, and if you're saying it was just nothing, if nothing had changed, it may have gone up incrementally. We don't know, but it wouldn't have gone to 800.
You don't know that. You don't know that. If you were to have, and I don't know exactly what the total average assessment increase was from 22 to 23. I know it was incremental, and it was more than double digits, I'm sure. So I can't answer that question, but I'm just saying you're comparing apples to oranges. Okay.
We'll ask the assessor.
Right.
What was that, Mary?
When we get to you, we'll ask you.
But in effect, I really think that that's immaterial. Whether you can sell it or not, I don't think that that has bearing. You have the control over when it gets recorded substantially, as soon as you have the document, which was within a week or so.
Okay, so I'd like to address that, okay? So I would agree with you to some extent. But I did not have control, okay? I was required to record the signed plan. The town had control of that plan, and the members of the board had control over when they went to sign it. I picked it up the day that it was ready, which was into April. It was after the fact. So I had no ability to do what you're suggesting that I could have done because it was under my control. It was not under my control. I didn't have control until after the April 1st date.
When I read the decision of approval, it doesn't say that the approval is contingent on your recording it in the registry.
Okay.
It says it's contingent on your closing prior to April 1st.
So I'd like to read again from the notice of decision from the chairman of the Camden Zoning Board of Appeals that the document will need to be recorded at the registry along with the survey. So I'm not sure how more clear that could be.
The following sentence clarifies it. It says, if you have not notified that the closing took place on March 29th, as previously stated, and do not have a revised purchase and sales agreement extending beyond that date, then the permission will expire. Those are the conditions of the approval.
So here, let's walk,
I think
We're not
Okay.
we're
in
in
the
the
right
wrong spot
place.
here.
All right.
yeah.
Sorry.
Yeah, and my argument again was not that I couldn't sell the lot, it's
I
that
need to
what
ask-
was the vested rights in that lot on that day, prior to the plan being recorded, were substantially different than if it had been.
What I am understanding is that at the end of March,
Yes,
you had purchased a piece of land that was not approved, did not have a plan, the surveyor had not drawn the plan, the surveyor had not signed the plan, and nobody had taken it to the registry to record it before April 1st, correct? So you didn't have the full ownership of it because the plan didn't even exist until after April 1st.
that is incorrect.
How is it incorrect?
The closing took place.
Yeah, you owned the land, but you owned land that didn't have a plan, that did not have a description that could be taken to the registry to record.
100% incorrect.
I think the
Okay.
plan date was February 23rd.
I purchased two
Plan,
separate
okay,
pieces.
the plan date, but is that signed? That was the whole question that they had.
No, it wasn't.
The plan was not signed.
So if it wasn't signed, is it legal? Does it carry any weight?
Yes. We'll come to that. I think we should move on to the town's presentation.
Okey-dokey. You all set with that?
Yes.
Congratulations. You get to speak.
Okay, thank you.
So, Bill Kelly for the town. I'm going to speak briefly just to the points because there's been some confusion about my writing and some confusion about what law you're actually applying here. I gave you a copy of the law that you are applying. It's in Exhibit B. It's important that you begin this and understand that subdivision law has no bearing on this. The recording date of the plan has no bearing on this. What does have bearing is the simple ordinance language, which is the same thing as a statute as far as the law goes. And you'll see in Exhibit B that there's not a lot of law here. There's just two provisions. And it's in Chapter 290, and I highlighted it for you in yellow. And it authorizes the division of a single lot of record that has two or more principal uses or structures. and that's authorized by the Board of Appeals, because this ordinance authorizes it. If this ordinance didn't authorize this, it wouldn't be possible, because otherwise it was a non-conforming law. So that is the authority for the Board of Appeals to act. And the second document I gave you was in non-conformance. And it doesn't have a lot of standards to it. And I highlighted that as well. If two or more principal uses or structures existed on a single lot of record on the effective date of this chapter, and that was important here. It's not for you, but that was determined at the town level. Each may be sold on a separate lot, provided the above referenced laws and rules are complied with. When such lots are divided, each lot thus created must be as conforming as possible to the dimensional requirements of this chapter. That's the whole set of standards for this act of the Board of Appeals. The division must be as conforming as possible. And that's what occurred. Nowhere in the ordinance is there a requirement, a legal requirement, of the recording of a plan. Nowhere in any statute is that required. The comment earlier was, I misunderstood subdivision law, which has a requirement to record a plan within 90 days of approval. Yes, of course, by a planning board and for a subdivision, not a mere division of a non-conforming lot. You've asked the questions, and appropriately so, well, when the heck were you supposed to record it? Well, it doesn't really matter. Now, I realize that goes against the grain of what a developer might think, but this is the way it works in a municipality. Boards of appeals have all kinds of authority to do things based on standards that are very fact-driven. In other words, you can move your cottage and expand it, but you have to move it back, and if you're going to expand that cottage that's on the water to the greatest extent practicable. You may have seen that standard before. What does that mean? It means surveys, it means approval, and it's fact-based at the Board of Appeals. Where does that go when it gets approved? The surveys, the findings of the Board of Appeals? It goes in the town record because that's the legal authority that approved it. There are hundreds of them. They're not in the registry. The assessor gets a copy of these and of course makes assessments based on what that lot is going to look like after it's improved. So the Board of Appeals is the authority under the ordinance that creates the opportunity, as was taken advantage of, to divide a lot that was non-conforming. That is the base of the records. So the first reference was that I failed to mention that a subdivision recorded by the planning board must be recorded in the registry. I'm glad you highlighted it. That's my point. It's not. The second point about this particular situation is, just like in a subdivision, could be 10 lots approved. You won't have a deed or a description of any of those lots until they're sold. It could be 50 years. I've had 50-year-old subdivisions get lots conveyed out for the first time. That's not determinative. Board of Appeals decision when they raised their hands was determinative. They had a hearing, had facts, they applied the law, they approved it. That was the date that the law of this lot was created. The other stuff was follow-up. The notice of appeal, a notice of a right to appeal, and the written decision are one. The notice of decision must be issued because the statute says it has to be issued within 7 days. The written decision, because that's how they do these things. Some towns don't. You probably have seen it before. Some towns, they'll just be the minutes and a record of a meeting, and that's the whole written decision. They never get to a written decision. Conditions. Let me just touch on this. It really doesn't matter what the conditions were at all. The vote of the Board of Appeals on March 22nd was what it was. There's always conditions. You can have a subdivision approved and 20 years later, when the lot is carved out or a lot is conveyed that was approved, and the conditions have to be met. It doesn't matter. The important thing is that it was approved by the Board of Appeals on March 22nd. And that's why I spend so much time on that, because that was the operative event. And there was no requirement that the plan be recorded. Yes, I understand the plan's got a line for the board to sign it. And yes, there was a written decision that came out after April 1st. Yes, those things happened. And they are confusing when you look at those and say, well, you had to record this for it to be legal. You did not. The Board of Appeals is like a judge. They made a decision. They did it as of the date that they did it, and the assessor is bound to follow that law of that case. He can't decide, as Mr. Libby's having trouble figuring out, when a plan is recorded in the future. And does the applicant, by the way, is he the one who decides whether or not the perfection of the Board of Appeals approval is accomplished on a given date? Does he get to decide that? Of course not. The Board of Appeals decided that. He submitted himself to the Board of Appeals when he filed his application. He submitted himself to the jurisdiction. His lot was under the decision of the Board of Appeals, just like any subdivision approval. If I get a subdivision approval and 5 years later I don't want that anymore, what do I have to do? I have to go back to the board that gave me that authority and I have to amend it. That's the way the law of the case works. It's a little less complicated in this situation because it was just a Board of Appeals. They're the very simple ordinance provisions that I just read you from Exhibit B, and that's all the law of this case is. That was what was done. There is a fatal flaw, of course, which I think you were all trying to figure out, which is at a $547,000 valuation of a single lot before he submitted himself to the board's jurisdiction and was approved to have this division. After that, the assessor appropriately assessed 2 different lots. The appeal is a valuation appeal. You have no evidence before you of any of the valuation, which is why you're having trouble with, what am I supposed to do with this? You're using a 2022 assessment, and you're saying it was inappropriate for 2023 because there were 2 lots. You picked the random value of 1 lot assigned, 408,000, and said, that's got to be 0. It doesn't make any sense. You have no evidence before you of what the value is in terms of the abatement requested. Or how would you possibly figure out the value of the property based on the evidence before you today, if you decided it was a single lot, if you did that? If you ignored everything I say, how do you figure out the value with the evidence before you? You can't. He hasn't met his burden. So there's a fatal flaw in all that. Otherwise, I just wanted to touch on those few points because we do have the law. It's in Exhibit B. It's very simple, and it has to be followed. The Board of Appeals didn't have authority to create more law. They didn't have authority to say you have 90 days to file a plan because of the subdivision statute. Inapplicable. It got filed at the Board of Appeals. That is the board of jurisdiction. That's the board. When everybody looks to see what happened in this case, that's where they look. And it happens all the time in all the municipalities you assessors work in. You look to the file for the lot in question. You don't have to see it recorded in the registry. You have value when there's a decision like this. You look at the decision, and that is exactly what you should look at. Kerry has some follow-up points, but I wanted to at least touch the legal points.
Thanks, Bill. I'll be fairly brief. One of the things I geek out on as an assessor is case law. I love to read it. And one of the things that I want to point out is something that they say over and over again in Supreme Court cases, and that's that plain language reading of the law is what we're supposed to do. Not read into it too deeply. You want to know what the intent of the legislature was when they created a law, and you just look for the plain language of it. And that's what I typically do. First of all, I want to blame the applicant here. Had you gone to the ZBA after April 1st, we wouldn't be here today. So,
Couldn't because
but April 1st is the whole big deal. This is not a subdivision. And I don't blame you for your confusion there, because we keep talking about subdivision law. This isn't a subdivision. It's just a lot split. What I find the weirdest part of the whole thing is everything that I've ever thought about with a non-conforming lot is you make it less non-conforming. In this case, and he's legally able to, so I'm not knocking it for this at all. But you're taking a non-conforming lot and you're creating 2 non-conforming lots. It just defies logic. But it's allowed. So okay, right. So when Ed came to me, first we had a meeting in my office, and when he explained everything to me, I thought, wow, it sounds like you're right, that we've got to do this. But then I did my research. And the first thing I went to was the decision and order. And again, I'm not going to try to read anything into anything. I'm just going to read what it says. And it says that a public hearing was held March 22nd, 2023. And then you skip along, and we get down to where the findings of fact are. And it says that upon discovering that the purchase and sale agreement, paragraph 8. Upon discovering that the purchase and sale agreement used by the applicant to be awarded standing would expire on March 23rd, 2 days from this decision, 2 days from a decision. And learning that the closing date for the transfer of ownership was March 29th, 6 days past the expiration of the agreement, the board agreed to place 2 conditions upon their approval. The applicant must obtain an extension of the expiration of the purchase and sale agreement to March 29th, and the applicant must provide proof of purchase of the property, or the approval would expire March 29th. So I read that and I think there's no way this is going into April. The approval was given March 22nd, and the applicant was told, if you don't meet these conditions by the 29th, that approval expired. We're talking about the approval, the date of the approval. The date of the approval was March 22nd. The applicant met the conditions, beat the clock by 2 days by having the purchase happen on the 27th. And so therefore, the approval that was made on the 22nd did not expire, and it was in force on March 22nd. That was what I read. Now, I agree in the notice of decision, this is reiterated again, the same thing about the dates, and it does say that the document will need to be recorded at the registry along with the survey. It doesn't mention a time constraint, it doesn't mention a condition, it's just talking about process and procedure. The approval was March 22nd. When it got registered was later. That's not part of the approval process. That's just part of the documentation.
That's all zoning board of appeals stuff. That's not assessing stuff.
Right. What's the question?
That was all zoning board of appeals stuff. That was not assessing stuff. That's not what we're here for.
That's right. That hits the nugget of it. The assessing stuff is the March 22nd to March 29th window.
No, the assessing stuff is April 1st. Was there a reasonable, recordable, was there a
I'm still doing my
recordable existing
presentation.
plan? Go ahead.
Okay, I've lost my place now. Okay, so in the applicant's statement of manifestly wrong assessment, which I always hate when that's read off like I'm dishonest or illegal and all this kind of stuff. But anyway, he writes that this was manifestly wrong because as of April 1st, 2023, the legal requirement to record the signed decision and order and the signed plan in the registry of deeds had not been done. That's reading into it. There is no requirement. That was one of the things I was referring to when I talked about the plain language of the law. It's just not there. It's not in statute. It's not in ordinance that this plan had to be recorded at the registry. One last thing, in a email Ed sent me, he mentioned the vesting of full rights of the subdivided lots as a recording in the signed plan. Again, that's nowhere in ordinance, it's nowhere in statute. It has nothing to do with the lot split. The lot was split on March 22nd, and that was how it was valued. Okay.
I have a question.
Yes.
Would you agree that if the approval expired, then you would have had on April 1st to assess it as a single lot?
Correct.
Okay, but at this point, when the conditions of the approval were met, you were bound to assess it as 2 separate lots.
That's right. That's right. Each lot was almost equal in the square footage, equal in the amount of waterfront and road frontage, and each had 1 building.
I have a question. Would the sales have had to have been undone as illegal sales?
Oh, thank you for bringing that up, because that was a point I wanted to make. Ed said had he gone to the CEO, he would have been denied a permit, but he didn't go. I don't think that's so. I mean, again, that's that's a ZBA thing, but he didn't go and wasn't denied, so it's a hypothetical.
What was the closing date on the properties?
March 27th. Oh, either one of us. March 27th, I think that's when the deed was signed.
The tax card says 27, so is that from the transfer tax form?
Yes.
Is that read?
So on March 27th, you owned 2 properties. You got it in 2 deeds or 1 deed? 2 deeds. March 27th, there were 2 deeds. So on April 1st, and I'll paraphrase this a little bit, you had 2 deeds for 2 non-conforming lots, pending the recording of the plan.
Yes.
So the question is, it's not whether the value is 0. Was there a difference in value of 2 lots on April 1st that were non-conforming, pending the recording of the plan? So the real question before us hasn't been asked.
But there wasn't a requirement for that.
Yeah,
Right,
but
there wasn't a
even
time
put on
requirement.
April 1st, there's 2 lots
Right.
that are non-conforming, pending the recording of,
Approved non-conforming
But what do
lots.
you mean pending? That wasn't a requirement.
The plan did not exist on April 1st.
we had
As a
we had the
recordable
transfer
instrument.
of 2
It was-
non-conforming lots.
Not every property gets sold with a plan,
Right.
though. You
Well,
still do
yes,
the
but there
division.
wasn't anything in the registry at that point.
Yeah, we're debating a little bit.
I mean, they
before we
have,
get there.
the
He
deeds
said
were, the deeds
that
were in the registry,
There was
right?
a lot.
Yeah, we're debating before we get there. So
Yeah.
that's the question I have.
Okay,
On
so
April
all these
1st.
people, we send all these people home.
So just to reiterate, on April 1st, we had 2 non-conforming lots.
Legal.
They weren't legal because
They were-
it was
the
subject
deeds were
to,
recorded.
Wait,
Deeds
there's-
were recorded.
just here to record it,
It's just a quick,
but they weren't allowed, okay. So the question of value is the only question we have before us. What is the value on April 1st of 2023 for these 2 lots?
but you have to premise that correctly. I mean,
Slightly.
if there's no requirement that it be registered, then there, what you're talking about being pending isn't an issue, because the records are on file at the town.
Right.
Marion, I have a question. Is there any record with the town of when the closing documents were presented to the planner? Because the notice of the decision says, at that point in time, the approval will be final.
Well, if it hadn't been presented to the planner by the 29th, it would have expired, so it had to be before the 29th, or on the 29th, on or before.
I can just say, there was an email to that effect from the applicant.
But isn't the planning,
We're
Isn't
dealing with
the-
value.
yeah, that's not
What was the value on April 1st, 2023 of each individual property?
exactly.
Is it time to move on to the next?
Well,
slide?
that's the thing of it.
Yeah, so I was wondering.
Are we ready to discuss, and do we have as much,
What was it?
I hope you all have as much information as you need, because I sure don't. I have no idea what I need.
Yeah, I think we're ready.
Do we need to make sure that we have no further testimony?
Oh, do we have, thank you. Is there any further testimony?
The only thing I'm not sure of your name, but,
Murphy.
again, I think that you're getting to the point is not about the deed and the legal, it's the value. And whether you believe when when the chair of the ZBA states that the document will need to be recorded, whether that is a requirement or not. I think that's an important question as to value. Because if you're gonna try to buy that lot and you come across this, and your attorney says, wait, it says it has to be recorded, you're gonna put the brakes on, and that creates a difference in value. Doesn't mean that it wasn't legal, doesn't mean it doesn't exist as a lot, it's just, what's the value? And does it have all the same, is it just like the lot next door? I say no, because there's nothing there left to do. Here, there is something left to do, and I think any attorney would say to their client, wait, you need to make sure this is recorded, because in this notice, it says it must be recorded. That's my point. So the value is different. It's legal, but the value is different.
Do we have anything else?
Just
from
briefly
the
on-
Assessors Department?
Thank you. Just briefly on that last point, even if we were to concede that the way that the issue was just framed by Mr. Libby, you have no evidence of it, so how would you determine it? So on that very particular point, his application fails. However, I can say that if I was doing the title on this, I would do exactly what I've described in my memo, which is I would look to the records at the Board of Appeals to determine whether or not what was the law of this lot, as we do all the time when we're doing title work, as realtors do when they go and investigate a case. That a piece of property that's up for sale, you look at the Code Enforcement Office record to figure out what is a binding law on that case. I think you're getting wrapped around the axle because there's a misunderstanding here that the law had to be reflected in the Registry of Deeds, which it did not. The law of this case is reflected in the town office records under the town ordinance law. That's the only thing that applies. That's my last comment about the value issue.
Can I just ask one more question? Carrie, how do you value a parcel that you don't have a legal description of?
I had a description.
You had a description, but it wasn't a signed by the surveyor recordable plan description.
There were 2 deeds that were signed.
I mean, not every,
Two deeds.
March 27th.
yeah, not every sale needs a survey.
And I had a copy of it.
Okay, where this was a split, you didn't need a survey.
Well, it's got needs and bounds.
Description of the deed.
Okay. All right, so we'll go with the description of the deed.
I
That was
do,
my
I do,
question.
I do mapping all the time. I love having a survey, but it hardly ever
Yeah,
happens.
it's always nice to have a survey, but it doesn't happen always.
Yeah. Thank you. Okay, are we ready to go into deliberation?
Yes.
Motion to close the testimony portion.
Do I hear that?
So moved.
Very good. Second?
Second.
Thank you very much. It has been moved and second that we close the testimony portion and move to the,
All in favor?
yeah. All in favor? 1, 2, 3, 4, 5, 6, 7. Thank you very much. Okay, you all may hang around and listen to us deliberate if you wish. You may not anymore talk to us. But you're welcome to stay if you wish, or leave if you have something better to do. Thank you very much. I appreciate all your work.
In terms of submitting this, who do I give it to? Just for
It doesn't have to
Yeah.
be accepted. Did we vote to accept that in? Did we vote to accept that in? It wasn't submitted by the time his deadline came,
Oh,
so doesn't it take a board vote to accept?
We object to it. We weren't given an opportunity to review it or comment on it. So
it's the.
I don't think we should accept it.
That's what happens.
No.
Right. Unfortunately, that's why there's deadlines,
Sure.
sorry.
No worries.
So that's why we took it out.
troubles with that.
Gotcha.
Mm.
Okay.
Some things after the.
Okay, I would like to discuss. Yes, I am.
Okay, I'll start. I think that we did have 2 legal lots before.
Yeah. I agree with that.
Okay,
Yeah,
they were
just-
purchased. They had descriptions.
Yeah.
They were lots.
See, to Lauren's point, you know, and she knows this because she does a lot of real estate,
Yes.
but when an attorney prepares a deed, they're doing all the title research on that property. They're not gonna allow a conveyance to happen without clear title, which means going back to the point of, wait a minute, did this get approved?
Right.
To me, you know, I don't want to be oversimplistic, guys, but, you know, with 2 deeds, to me, that establishes
2 lots.
2 lots.
Okay.
Right.
Because I know that I can bring a buyer to the table, and that buyer can then go do something with that.
So if the lot's got, if each one got sold 60 days later, it's gonna be a little bit of a messy closing.
Yeah,
Until
yeah.
you've got that documentation from the ZBA that says these are two separate lots. And someone's going to find that, and we're going to have.
You have the approval letter, right? You
So
have the
we need
approval
to,
and their
you're saying
decision.
stuff, but I need to get stuff that
Oh,
I
we're just
can write
discussing,
down
we're just discussing.
here. Okay,
But
we've
the,
got 2 lots existed before April 1st of '23, so far.
well, the question I see is, what was the value on April 1st for these lots?
1 lot. We're only
Two,
doing 1
two
lot.
lots. You get 2 lots on April 1st. So what is the
Are
value
we,
of each
are
lot?
we appealing, are we having an appeal for both lots?
We're having
No.
just a discussion.
Well, okay, so,
So, look, let me keep going. Yeah. So, we've got 2 lots on April 1st. They each have a value by the assessor. The applicant is saying one of the lots is 0. I don't buy that.
mm,
I don't buy that at all.
Okay.
There's no
Do you
demonstration.
buy that it is a decreased value because it is lacking the ability to develop or get a building permit or, you know,
No.
that kind of stuff?
We're not presented any evidence for or against that. We're presented that,
That
the
was in-
contention, the
was in
contention of the
Mr.
property owners that the value
presentation.
is 0.
I think that was a hypothetical though, I mean, a building permit wasn't denied.
Yeah, we don't know any of that. It's not
Okay.
happening. So I'll circle back and keep putting this on the staff. On April 1st, there are 2 lots. Is there any evidence to support the applicant's opinion that the second lot had no land value in the building value? I think the argument comes down to that pretty close. Maybe there's a few more copies.
so then are we honing in on 1 lot or 2 lots?
This appeals for 1
We should be
lot.
looking at the 1 lot.
We're looking at map 107, lot 37-1. So his appeal says that as of April 1st, that lot had 0 value.
Yeah,
Yeah,
Even if it was looked at as 1 lot, it would have value.
But we have no evidence.
But we do not have any evidence. Right.
Was the
when you
lot
don't
value
have any
diminished because they were split? Was the lot value diminished to 0?
I mean, I think the only evidence of value we have is the tax card, right?
say it again, Lou?
The town's value, the tax card. So if there was a reduced value, we don't know what that would be.
Would the assessor have said, okay, I'm
We
gonna
have a
do,
tax card
I'm gonna
in
do
someplace, but I don't know
X
what year it's been.
because I don't know that this has been recorded yet or whatever. But we don't know that.
Marion, I have it right here, this is the plan. Just make sure on 37-1, because there's 2 of them.
I hate vision cards.
I like them.
I hate trio cards.
I hate trio cards
I
too.
don't like trio either.
I've worked with both of them.
You did too.
You're all
I'm
trio.
not fond of either one.
All the systems have the pluses and minuses.
Wait,
Yeah.
don't your offices have the state of Maine handwritten cards?
Oh my God. We'll talk afterwards, I'll tell you.
Okay, so I've got,
We
I'm
don't have
pulling
any
out
evidence.
the property card that we were given for this parcel. I'm looking for, the print date is October 26th of '23. I don't see an April 1st
There,
of
it's, it's going to be on a, this is a working document,
Yeah, this is
It's
not
not
a,
official commitment.
that's not much.
So the question I have is that the value per the applicant is 0. Where's the evidence for that?
Where's the what?
Where's the evidence for that? We don't have anything,
Do we have any, okay, do we have any evidence?
the town's assessment will go first, as there's a value. We don't have any evidence by the applicant, which is his burden to show that that value is zero.
Yeah,
And we don't
Okay.
have any of that.
and do we have any, we do not have any other evidence?
On April 1st, there were 2 lots, they were assessed. No evidence on the second lot that the value was zero.
Mhm.
I think I quoted that pretty close to right to the bottom of the payment.
Yeah.
So,
Okay. Is there anything here?
I think you can go down through this.
You're looking to find the facts? Yeah, you ready to go through those?
Trying to find a finding of fact that was even remotely close to being relevant.
What your guesstimate was?
I think we could say one is as of April 1st, there were 2 lots.
Yeah, got that.
Yes, sorry.
Yep.
Which one are you on now?
Oh, he's just saying April 1st, 23.
Two lots exist.
2 recorded deeds. No. Let's not
No.
get too complicated, James.
No.
Go ahead, James. 2 already said.
Okay, 2 lots existed. That's as far as I got before, too.
2.
No, I got that twice. Okay.
I don't know if this is, yeah, I guess.
Okay,
this-
what about, can we use the percentage of value, the last, at the very bottom of the second page?
No.
The percentage of the value of the subject lot lost by virtue of its not being saleable or developable as of April 1st, 2023 is?
No,
No.
nothing presented that demonstrated anything.
Okay, so, no evidence.
I'm really, number 2 lots existed. Number 2, I'll suggest no evidence was presented that the lot, I'm gonna go right down the line. That map 107, Camden's Assessor's Records, map 107, 37-1.
Wait a minute. No evidence presented?
4,
Yeah.
that the land and building values were 0.
Okay, lot.
Map 107.
Let's see, lot 37 dash. Okay, that
The applicant did not present evidence.
no evidence presented for this lot that there was no value,
That the value was 0.
that the value was no. What else can we say?
That's-
It's gonna be a pretty short one.
Right, I mean, you can make sure that in the finding of facts that we agree that, March 22nd was the date of the Camden zoning board of appeals approval
Okay.
of that,
Yeah,
right?
but that isn't, it doesn't have anything to do with the assessment of the property.
I'm only deciding that.
Yeah, I guess that sort of factors into how we got to number 1. I
Right.
think. Yeah.
So, does Wendy have that? Because I
So you're
don't.
gonna just weigh this all on the valuation and not through the process in which they went through?
Right.
Is that what
Well, and that's what the
everybody else
question is. The question is, what is the value?
That was about on April 1st.
I mean, I think if I was doing this title, I look at the order and there would be a question about whether there should be a recorded survey, but I don't think that's something that the assessor would factor into the value, is it?
We've got
No.
2 deeds on March
You have two,
27th.
yeah, you have 2 deeds on March 27th. That's before April 1st, the ownership was already taken place.
So I'll mention that as an assessor, I am not the title attorney, I'm not the surveyor, I'm not the Indian chief, I'm not a lot of things, I'm the assessor on April 1st. What is the value on April
What is
1st?
the value, exactly?
Was the value 0 on April 1st? The applicant did not demonstrate that there's
Yeah.
a 0 value on April 1st. I think this is a brief findings of fact. Yeah.
That might be it.
Okay, so I got 2 sentences.
Yeah.
Well, we usually talk a lot.
That's all right.
I will say, after reading all the materials, it's not where I thought we'd end up.
No, it is not.
It's a good thing you listened to.
I mean, had there
Okay,
Has
so
there been a
the
value?
last,
assigned
the
to
last
value, we would
potential
end up
finding
differently.
of fact, the 100% taxable value of the subject lot as of April 1st, 2023 is,
Nobody presented, well.
There's not.
well.
Well, we
it
do, we
is
have
what
the
it
property
is on
record
the-
card. We have the property record card that says that.
Right, but that's not the question. The question is, did the applicant provide anything that said it was anything different?
Well, so are we ruling that it is what it was?
You can go down the road. I would rather not go down the road.
You don't want to document that.
Which road?
He doesn't want to document the fact that it's got a value as of April 1st and what that value is taken from the property value.
I mean, but that's presented to
Yeah,
us.
There's no
That's
testimony.
presented to us though.
Okay.
Well, the
There's
testimony was the property card, which was handed to us.
Right, and we can't ignore that.
Right.
Okay, y'all wrestle about this.
Okay.
We
Well,
can say the town presented the value
Right.
as,
yeah, I'd rather have that.
Town of Camden, right, property record card shows as of April 1, 2023.
Talk slower. Town of Camden assessment. Well, it was actually the appellant that showed, gave us this.
No, well, the property record.
Card.
Yeah.
Indicates value. As of,
I'm not entirely happy with that, just so you know.
Yeah.
that's good,
Yeah,
that's
I'm
fine.
acquiescing. So,
you mean of
I think it's the
including,
most
of
important.
including the assessed value?
Yeah.
To me, I would have wanted to see a tax bill and not a property card. I don't know whether there was any intermediate adjustments made in the valuation on the on the tax card. I don't know that tax card is actually of April 1st, is it? Might be April 1st, but
The only controlling document for valuation is the commitment book. Everything else is a work.
Well, we do, I mean, we also have this document that states the assessed value.
yes.
So, well, from that end, that's what I'm supposed to, that's why I didn't care about it. We're here to look at evidence.
So are we including that statement about the 408,200?
I'm just saying, I'm not
Or
making
not.
any statement about the value of the property.
Yeah.
That wasn't.
Okay, want to have a preliminary vote on that?
So your heart runs over including the value period?
I'm with everyone except the.
Are we going to put that in the
I'm saying
decision?
there was insufficient information presented of the value of any of the properties.
I
And
don't
just
think
leave
we're,
it at that?
I don't think we're saying that's our opinion of the value, but it was stated in
It was
multiple
stating in multiple
documents.
places.
It, like, it's in this application, it's in this application, it's in.
And it's the town property card. There's three, at least 3 spots in the materials that we have state the same valuation.
Right.
I think
408,200.
Wes, they just want to make a statement as to the value.
No,
I would just
saying-
like to say one thing. basic law of assessment is that the assessor's value is assumed to be correct unless evidence is presented
Absolutely.
otherwise. So
So
that's
we're
basic.
manifestly wrong.
Yeah.
We've not seen that.
So we could just say evidence was presented that the assessed value was.
It's a
And then
statement
put
of-
another.
The
statement
assessed
of-
value
there.
is what it was.
Statement of fact, right.
And then something on the fact that the appellant didn't have any documentation to
Support zero.
support zero.
Okay, I've got no evidence was presented for
I think we,
map
that
that
was
the
number
value
two.
was 0 as of April 1st, 23. I've got that. Okay, so somebody said something differently on the 48200. I didn't catch it.
Evidence was presented that the tax assessed value as of.
No,
sorry,
evidence
sorry.
was. Old person here. Evidence was presented.
That the tax assessed value as of April 1st, 2023 was 408,200.
it's a statement.
Yep.
Okay. Do you need any more?
We have
facts?
3 items. Anybody have any desire to make a 4th? Everybody happy with 3?
Do you need
Yep.
to?
Would you like to vote on that?
Is that what you want?
No, I just don't like, do we have to be in agreement that, that the zoning board acted on this date, bring that into play through, so that there's record that we acknowledge that that actually took place?
I don't think that's a valuation question for us. Only because of the deed recording was prior to April 1st.
All you need to know
That's
is
all.
whether there were 2 lots or 1 lot
On
as of
April
April 1st.
And there were two.
And there were 2.
Yeah.
Right, we all agree on
Stated
that.
that.
That's easy.
We have, as of April 1st, 23, 2 lots existed.
That's correct.
The second one is no evidence was presented for map 107, lot 37-1, that the value was 0 as of April 1st of 23. And the third is evidence was presented that the assessed value as of April 1st of 23 was 408,200.
Right, do you need to break that down into land and buildings, or you gonna just do it,
I don't
just
think
the
we
whole,
have to.
right, it's the whole value anyway, so.
Want a motion to findings of fact?
Yep.
So moved.
Second?
All in favor?
I'll make a
Thank
motion
you very
that,
much.
based on the findings of fact, that the applicant did not meet their burden of proof. The valuation was illegal.
Wait a minute. Was illegal?
Was manifestly wrong.
All those,
Those words.
all of those, yeah,
Okay.
they're in here someplace.
They are, right at the second
I've
page
got
of
that
that
over and
application.
over here someplace.
Yeah.
And the tree down for us.
Findings of fact don't match. We need to report it.
Okay, there it is. Got it.
Yep.
Yeah. Okay.
I know you're gonna word this up correctly, but for signatures.
Judgment. just wanted to know that that was where I was gonna put that.
You want to read that?
The applicant did not meet the burden of proof that the judgment of the assessor was irrational or so unreasonable in light of the circumstances that the property is substantially overvalued and an injustice results, that there was unjust discrimination, or the assessment was fraudulent, dishonest, or illegal.
I'll make that motion.
Second?
All in favor? You done? Motion to go home.
So moved.
Second?
All in favor? Aye.
Actually, that's wrong.
Thank you.
Thank you all.